Hi, and welcome back to the Chapter 4 lecture presentation in your workers' compensation curriculum. Before we jump into Chapter 4, I want to do a brief review of what we learned so far. Chapter 1 was an introduction to the system, just giving you an overview of what workers' compensation is and generally how it works. Chapter 2, we reviewed the federal workers' compensation system. Remember, workers' compensation is generally state law, but there is a federal system. In Chapter 3, we looked at the definitions of employer and employee. Generally speaking, if an employer fits the definition of employer under a workers' compensation statute, then they are required to pay into the workers' compensation insurance program and provide benefits for their workers. On the other side, if an employee qualifies under the definition of employee in a workers' compensation statute and they get injured on the job, then they receive those benefits. So Chapter 4 kind of brings those definitional sections full circle in that we're going to look at what injuries qualify for the benefits. So at this point, we're assuming that the employer fits under the definition of employer, required to provide workers' compensation. The employee fits under the definition of employee, and therefore those benefits are available to them. So what triggers those benefits? Well, it's going to be an injury, as that term is defined in the statute. So by the time we finish this chapter, this learning module, I want you to be able to describe the injuries that are covered under workers' compensation laws generally. I want you to be able to define the regulations that govern the reporting of injuries occurring on the job. Describe how injuries are considered to be arising out of employment. That's going to be an important term for you to understand. Explain the concept of detour and frolic, and describe occupational illnesses. The focus of this chapter is defining what constitutes an injury. It's simple common sense to state that just because a worker is injured does not necessarily mean that the injury is covered by workers' compensation law. This chapter explains injuries arising out of and in the course of employment, as well as the implications for the employee for doctrines such as frolic and detour, and dual-purpose trips. In addition, the chapter discusses and distinguishes between psychological injuries, horseplay, and acts of nature. Finally, the chapter explores issues surrounding pre-existing injuries. So let's jump in and start talking about the bulk of Chapter 4. So in this chapter, we'll focus on what qualifies as a job-related injury, and we'll also examine the related issue of reporting injuries. In order to be compensable under workers' compensation statutes, an injury must arise out of employment duties and be in the course of employment. So we're going to examine these terms in detail, and we're also going to discuss some exceptions or some things that would take it out of the course of employment. As far as reporting goes, there's really two parts to it. First, the employee is required to promptly report the injury to the employer, and once done, the employer is required to promptly report and treat the injury. Before we address specific examples of work-related injuries, I need you to understand that there are two legal elements that an employee must show before he or she can claim workers' compensation benefits. One is that the injury arises out of the job and their duties, and the other is that the injury occurred during the course of employment. This is not an either-or thing. The employee has to show both of these. So think of these like the elements of the definition. Now, the reason behind these two requirements is that we're trying to create this direct causational link between work and the injury. Remember from our discussion that both sides are giving up important rights here. The employer side is paying into the system and giving some defined benefits, some protection to the employee, but the employee is giving up the right to sue under tort law. But the cornerstone of this system is that the injury be work-related. If the injury occurs on the job, then the employer is responsible for providing the benefits. If it's not on the job, though, the employer has no responsibility to provide medical benefits and coverage. So that seems to make sense. But this arising out of or on the job requires more than the employee be just at work. There can be instances where the injury is not arising out of or in the course of the employee's employment. Courts are generally very liberal when determining what is arising out of or in the course of employment. And they've also held that if you're generally within the scope of your duties, that's a general scope of your duties, then your injury is going to be compensable. When we're talking about defining in the course of, what we're really looking at is, was the injury a consequence of the job duties, or was it caused by the employee's negligence or during a period of time when they weren't carrying out their duties? So if you think about it, if your boss tells you to carry a plank of wood down the hallway, and while you're carrying it you trip and you hurt yourself, that's arising out of and in the course of your duties. But what if you are on the way to where you're supposed to be going and you put that piece of wood down and you go into the cafeteria and get a sandwich? You're on a break at that point. Is that in the course of your duties or arising out of your job? So travel to and from work is sort of our first exception. In most circumstances, traveling to your job or once your job is over and leaving your job is not considered arising out of or in the course of your employment. However, there are some exceptions to the exception, if you will. If the employee is traveling as a part of their job, that's a different story. And also, if you're away on business and you're traveling from a hotel that the company's paying for to a place of employment or where you're going to perform your job duties that day, or back to the hotel at the end of the day, that could be considered part of your job. So let's say that you're a paralegal working here in Jacksonville and your law firm sends you to Raleigh for some continuing professional education. They put you up in a hotel overnight. In the morning you get up and you get in your car and you start to drive over to the place where you're going to take the training. In the course of getting there, you get in an accident and you're injured. In this case, staying at the hotel and going to that training, part of your job. So the injury would be covered by workers' compensation insurance. Let's look at some more exceptions and the concepts of frolic and detour. And let's take that same example. You're sent to Raleigh to stay at a hotel and go to some continuing professional education. In the morning, you get up and you're headed into where the training is going to take place, but you decide you want to go see your sister who lives about a half an hour out of the way. Instead of going directly to the training center, you take that half an hour detour. At that point, once you get on that detour, you're on your own because going to see your sister, not part of your job. So that is considered a frolic or a detour. So once you make your turn off of the main route into the training center, you're on your own time. And if you get injured while you're on your way to or back from your sister's, at that point, you're going to be responsible for your own injury, and your workers' compensation is probably not going to cover the injury. So we talked about frolic and detour, which kind of take you out of your way and put you on your own time. But what about if your sister's house is on the way to the training center? So you plan on getting up in the morning and on the way to the training center, stopping at your sister's house. It's not out of the way. It's not a frolic. It's not a detour. But before you get to your sister's house, you get in an accident and you're injured. At that point, we're talking about what's called a dual purpose trip because you're not really going out of your way. So you'd still be covered at that point. There's no real defined time or distance that would qualify as frolic or detour. It's going to be a totality of the circumstance type discussion. Next exception is horseplay, and this is going to look a lot like coworker caused injuries, right? If you're supposed to be doing your job and instead you're engaged in messing around with some other employees, and while you're messing around, you end up getting injured, that's not going to be covered because that horseplay obviously doesn't arise out of your job duties, right? Next exception is acts of God or nature. Just because you're at work doesn't mean workers' compensation covers. So let's say you're at work and an earthquake takes place, and the earthquake causes the building to fall in, and of course you get injured because you're inside the building. Well, that is an intervening cause that doesn't arise of. It's not related to your job. It's an act of nature. So those types of things not covered by workers' compensation insurance. Assault by a coworker or assault by somebody else that comes into your place of work, not covered, not the employer's responsibility, doesn't arise out of your job duties. I can't think of a situation except for maybe a police officer or some type of peace officer where assault may be actually part of your job duties. If it is, then it's covered. Most times not. Let's talk about some of the different kinds of injuries. Psychological injuries, injuries that you can't see physically. We're talking about traumatic brain injuries and things like that, can be covered if they are related. So it doesn't have to be a visible injury. Psychological injuries can be covered by workers' compensation. Pre-existing injuries is an interesting area because it's treated differently than in tort law. If we're talking about tort law and somebody has a pre-existing injury, that is exacerbated by a breach of a duty, generally speaking, the defendant in the case is not responsible for the entire injury, just the additional injury. Workers' compensation law, completely different. the way we look at this is that employers accept employees sort of with all fault. So if they come in with a pre-existing injury, and that injury is exacerbated at work, arising out of the course of their work, or creates a subsequent injury, then the entire person, the entire injury, all the medical is covered under workers' compensation. So it's a much broader coverage than you might find under tort law. In the case of intoxication, the question may seem simple, right? If you're drunk and you injure yourself, that sounds like something that may be outside the scope of your employment. But it depends on whether it's voluntary or involuntary intoxication. Obviously, if you come into work with a fifth of liquor and you down that and you end up getting injured because you were drunk, the employer or the workers' compensation insurance is not going to be responsible for that. The issues surrounding occupational diseases can be pretty complex, and occupational diseases are injuries that arise out of a specific type of employment. If you want to think about occupational diseases, think about the firemen, the first responders during 9/11 and how they contracted some of those lung issues. You can think about people that work with asbestos, and how they developed a cancer from it, in the military, Agent Orange, and things that are specific to a certain occupation. The most basic definition of an occupational disease is an illness or a condition that is caused by or aggravated by the nature of a particular employee's work. Most times you're going to see under state law that these occupational diseases are specifically listed in state statutes and therefore covered by state workers' compensation laws. So let's kind of bring everything full circle and talk about how the court decides whether or not an injury is arising out of or in the course of the employee's employment. Because there's gray areas like we talked about. Remember our example where you're walking down the hallway with a plank of wood and you put the wood down and you go in to get some lunch, right? Well, that's sort of a gray area, and that's not strictly related to work. But is it something that we want to accept from the workers' compensation protections? And courts have developed several doctrines to deal with situations like this. The most prominent is what's called the personal comfort doctrine. So under the personal comfort doctrine, an employee who is engaged in carrying out normal work activity and stops to get a drink or walks to the cafeteria for lunch, those kind of things that are for personal comfort during the course of employment are probably going to be covered. If it turns into a frolic and detour, it goes beyond the personal comfort, then you've got a different situation. So you want to look at those things closely. So in this chapter, we've learned that an employee who was injured on the job must prove two things: that the injury arose out of and in the course of his or her job duties. Employees are running personal errands, performing non-job related activities are not covered under the workers' compensation system. And therefore, if they're injured, their injuries won't be covered. There's often a conflict about how to define work-related injuries, requiring courts to develop several doctrines to address the issue of what qualifies as an on-the-job injury. Some injuries qualify as occupational diseases. Again, they're probably going to be listed in a state statute and are probably compensable if they are listed. But the main thing we're looking for is that causal connection between the nature of the injury and the employee's activities. But don't forget your reporting requirements as well. The employee has to report, and then the employer has to treat and report. So that's a brief overview of Chapter 4 and what qualifies as an injury and therefore gains coverage under workers' compensation system. As always, don't hesitate to contact me if you have any questions, and I hope you have a great week.